not this time. Federal Judge Dale E. Ho already knows that 7 prosecutors have resigned from the Justice Department because they refused to file the motion to dismiss, believing it to be based on a lie. The acting U.S. Attorney for the Southern District of New York sent an eloquent resignation letter to the acting Deputy Attorney General, who was one of Donald Trump's criminal defense lawyers. Danielle Sassoon's letter said, quote, "I cannot fulfill my obligations effectively, lead my office in carrying out the department's priorities, or credibly represent the government before the courts if I seek to dismiss the Adams case on this record." 6 more prosecutors resigned since that time over the same issue. 3 former U.S. attorneys sent Judge Ho a letter asking him to sharply question the prosecutor's motives for dismissing the case. They wrote, "The public furor that has arisen during the past week raises concerns about respect for the rule of law and the division of power between the executive and judicial branches of government of our nation." Common Cause also sent a letter to the judge asking him to deny the motion to dismiss because it is part of a, quote, quid pro quo bargain. The bargain described in her resignation letter by Danielle Sassoon is that Mayor Eric Adams will cooperate with the Trump administration in vigorously enforcing their mass deportation program, which Danielle Sassoon insisted was an improper quid pro quo agreement. Also today, New York Governor Kathy Hochul met with New York City officials and community representatives to consider whether Mayor Adams is still capable of doing his job. It has been falsely reported that the governor of New York has the power to summarily fire the mayor of New York, which has led to uninformed commentary like this.
"I'm sorry, the governor of New York is a dope. Why she doesn't get that guy out of there pronto, I have no idea."
Adult. Okay. The answer is the governor cannot get rid of the mayor pronto. And that is why she hasn't done it. What the governor can do is call a hearing about the mayor's transgressions in which the mayor is allowed to be represented by lawyers and vigorously defend himself, including calling as many witnesses as he wants. There is no rule about how long such a hearing can go on, but the governor must be present for every minute because the governor is the judge in that hearing, and the governor is the prosecutor in that hearing, and the governor is the jury in that hearing, rendering the final verdict. The governor alone decides the outcome of that hearing, and such a hearing has never happened before. And the mayor can appeal to the courts about anything he doesn't like about that hearing, and he can fight his appeal all the way to the United States Supreme Court, all of which could take years. So anyone who tells you that the governor can fire the mayor pronto is wrong. The governor cannot fire the mayor. The governor can initiate an untested procedure that could have an unpredictable result, no matter what the governor thinks of the evidence. And all of the evidence of criminal conduct by the mayor would continue to be locked down by Donald Trump's federal prosecutors, who won't allow the governor to see one bit of the criminal evidence obtained by the FBI against the mayor. So what exactly would the governor's hearing be about?